Schechter.
Good evening. Thank you very much, Christy, and thank you to the Bayville Library, which is kindly hosting this program on basic estate planning. I hope it will be interesting and informative for all of you. And I just wanted to start by saying I am not giving legal advice or answers to any specific questions, but I'm happy to discuss various issues involving estate planning with you. And if you have questions, you can ask them in the chat box or afterwards. I'm going to share my PowerPoint presentation with you. I hope that everyone can see it. If you have any difficulty hearing me or seeing my PowerPoint presentation, please let us know in the chat box. So this is my information, Zahava Schechter. Hold on one second. And let me see why it is not going forward. Hold on one second, sorry. Okay, there we go. So if you have a question, please type your question in the chat box, or you can reach me afterwards, either by phone or email. I'm happy to answer your questions. I just want to give a very brief introduction for myself. I'm an attorney with 30 years of experience. I do primarily the areas of law. I practice primarily the areas of law you see, estate planning and administration, both before someone either becomes incapacitated or dies, and then afterwards I help the family, as well as real estate conveyances, houses, co-ops, condos, and commercial properties. And I also handle business law matters. I also do a podcast. If you like to listen to podcasts, all things Long Island about law, feel free to take a listen. You might, find it very interesting. I want to start the presentation with a link to a website, which you may or may not be aware of. It's the New York State Office of Unclaimed Funds. And there is the website address. The unclaimed funds so far returned this year in 2021, you see it's over $34 million. And right now, New York State is holding $16.5 billion. So what is this website and this money? Well, sometimes either a financial institution or a life insurance company or some other creditor is holding money for a New York State resident and cannot find that resident. So the money, escheat is what it's called, ESCHEAT. Escheats to New York State. And if the New York State resident, who is the legal owner of this money, does not claim it, New York State keeps it. So I regularly look through this website for my clients to find money for them. In the last 2 weeks alone, I have found money for more than 10 clients. So I strongly recommend you go there, you look around for your name, for your family's names, and hopefully you'll be surprised and you'll be able to claim this found money. So tonight we're going to talk about 3 basic documents involved in estate planning: the healthcare proxy, the durable power of attorney, and the last will and testament. We'll also talk about miscellaneous items as well as different kinds of trusts, but I want to focus on these documents. So today I was speaking with a prospective client who is a contractor, and I gave an example of these documents as a foundation. If you're building your legal and financial house, you need a foundation. This is the foundation to your estate planning. So the first 2 documents, the healthcare proxy and the power of attorney, are only good when you're alive. And the last will and testament is valid and effective after you die. We're going to talk about these in more detail. I want to start with the healthcare proxy, and I hope many of you have received, if not all of you have received, the worksheet, which I provided to the library, because we're going to work on that a little bit now. I want to explain about a healthcare proxy. Today, if you present yourself at a hospital or at a doctor's office, and you're able to understand, I'm talking about mental capacity, you're able to understand and to communicate, whether verbally or by blinking your eye or in some other way, that the doctors clearly know what it is you want for your healthcare decisions. And by healthcare decisions, I mean if you want surgery or don't, if you want certain medication, which hospital you want, which doctor you want, anything involving medical care. If you're able to do that, meaning understand and explain everything, no one else can make healthcare decisions for you. So let's say the doctors recommend that you have a certain operation. And they say to me, and Zahava says, no, I don't want it. It doesn't matter what your spouse thinks, what your doctor thinks. If you're able to handle your own affairs, you're the only one who can make those decisions. But what happens if you can't? What happens if either, God forbid, you're in a coma, or there's dementia or Alzheimer's, or for whatever reason, you cannot communicate your healthcare wishes? Then the doctor makes a decision. So sometimes I have people who say to me, oh, well, my spouse, I'm sure, will make the decision. And the answer is no, it's not your spouse. Everyone over the age, 18 years old or over that age, are considered to be adults. That's the age of majority in New York State. And we have a right to our own decision-making ability as well as our privacy. So for example, if any of you have children, ages 18 or over, as I do, all of my children are over the age of 18. I am not entitled to see their records. I am not entitled to make any decisions on their behalf. They are adults. And unless they empower me through a healthcare proxy, I will have no say in their decision-making. So healthcare proxies are very important. In addition to being able to make decisions, you also can receive information, the HIPAA release. So for example, as I said, without a healthcare proxy, I can't get my children's health records. If you want your loved one's health records and you have not been named the agent, you can't get it. In addition, the healthcare proxy gives instructions. The primary instructions are, there are many of them, but the primary one is either do not resuscitate or keep alive at all costs. I want to talk about that for a minute. Do not resuscitate does not mean don't keep me alive if I have a chance of surviving. They're going to do whatever they can to keep you functioning, no matter what. The question becomes, if the doctors say you have no reasonable chance of surviving other than in a vegetative state, meaning you will not be able to do things on behalf of yourself, do you want to live like that? And the big issue in New York is also not so much plugging in on a resuscitator, but unplugging. And why is that? Because New York state courts have ruled that there is no right to assisted suicide in New York State. So as a result, if you're incapacitated and you're plugged into a machine, there's a very good chance that if you're unplugged, you may not survive. And those issues come into play. Obviously, this is just a beginner, a primer, but I'm just giving you some issues. On the other hand, you have, that's one spectrum, the do not resuscitate. The other spectrum is keep alive at all costs, no matter what. You want to remain alive. You want the doctors to do whatever is necessary so that even if it's artificial breathing, you remain alive in that category. And then, of course, there's all this gray in between. In addition, we deal with organ donation. So as many of you know, once you are considered brain dead, if you want to donate organs, those organs don't last for a long time. A healthcare proxy provided to your doctor or the hospital provides the ability for the hospital, if you so wish, to harvest any of the organs you've specified to help someone else survive. Burial or cremation instructions, very important. I've had, over the years, my 30 years, I've had very interesting clients, some of whom had very specific instructions, how they wanted their end of life issues and ceremonies to take place. This is a great way for you to tell your family what you want. Again, the proxy agent whom you choose is so important. You should choose somebody who either sees things from your perspective, or even if not, then at least respects your wishes. And you must also have at least one backup successor agent, because what if the person you name either is unavailable, has predeceased, or is not willing to make these very hard decisions? You need a backup person. So at this point, if you have the worksheet, I'd like you to take it out, please. What we're going to do is not legally binding in any way, but I was thinking that this might be a good way for you to give some thought to your own end of life issues, especially during COVID. And by the way, I normally start by saying, I hope everyone is well and that we stay well. During this pandemic, a lot of people have thought about their end of life issues and what would happen if they become ill. How would they want their health care to look like? What kind of decisions would they want made for them? So if you have the worksheet, if you want to write down your answers, you're not sharing it with anyone, it's just for you. But I thought it might give you some food for thought. Whom would you choose as your healthcare agent? Very important. So some factors to consider. Proximity. Somebody who lives in California is probably not as good an option as someone who lives here in New York. Why? That person may need to come to New York, whether to the hospital or may need to be available for other reasons. And so proximity is an important issue. Of course, if you only have one person in California whom you trust, that person, thankfully you have. But all else being equal, if somebody lives closer to you, where you live, that's an important factor. Age and health of candidate. So when I have clients who are in there, and I have clients from 30s, 20s, 30s to 80s, 90s. When I have clients who are in their 70s and they tell me they want to name someone also in their 70s or 80s, I ask them to at least name one backup person, because none of us knows how long we're going to live, right? But the older you are and the older your agent is, the greater the chance that maybe that person will not live as long. Of course, there's no guarantee just because someone is younger in years that that person will survive, but there's a better chance. Willingness to act as agent. You should always speak with your agent. Are you able, are you willing to make these decisions? These are hard decisions, life and death decisions. So if somebody isn't really well suited to make these decisions, probably better not to name them. As we discussed, similar to you, view of healthcare decisions. For example, I'm going to share with you something personal. My husband wants to be kept alive at all costs. I don't quite share that view with him. And yet he has named me as his agent. This is a true story. And that's because I respect his decision. That's what he wants for himself. And so we've had a long talk about it. But if, for example, you ask somebody to be your agent and that person says, no, I totally disagree with you, that's not the way I see it, that is probably not the best person for you. You want someone who would do what you would do if you were able to make that decision. Okay, who is your successor healthcare agent? Meaning the backup. Who would be willing to do so? A lot of people don't think about that. They think about one person. Okay, I have an agent. But again, if that first agent is unavailable, predeceases you, or changes his or her mind and doesn't want to be available, that's really a shame that you don't have that successor to make decisions. Okay, I also pick a third person. And by the way, I don't know if you noticed, I use singular words here, agent. I don't say agents. Sometimes people come to me and they say, oh, I want to name my 2 children. Well, I don't suggest that. I don't suggest naming more than one person. Why? How many times do 2 people actually agree? Maybe they do agree, but maybe they won't agree. And if so, if you name 2 people and they don't agree on a decision, then no decision is taken. And often no decision is worse than a decision. In addition, if you name 2 agents, they both have to be available. Oftentimes people are not. So now, what are your end of life wishes? Again, you're not sharing this with anyone. What do you want? Do you want keep alive at all costs, no matter what? Or do you want do not resuscitate if the doctors say you would be in a vegetative state? Or do you want something in between? And that's fine too. There is no cookie cutter document, none. Every family is different. Every family situation is different. So what would that look like for you? Because again, all that matters is what you want, not what anyone else wants, not a spouse, not a child, not the lawyer, not the doctor. What you want is paramount. Do you want to make an anatomical gift? Basically organ donation. And if so, are there limitations? I've had clients who have said, I don't want my skin to be donated. I don't want this to be donated. You know, this is often a religious issue too. Some people say, no, you know, according to my religion, I want to be buried whole. That's fine too. But if you do want to be, an organ donor, even though many of us have it on our driver's licenses as well, the best place to have it, frankly, is on a healthcare proxy. One other thing I want to say about a healthcare proxy, and then, we're going to go ahead. Well, one more thing I'll say here, and then we'll move on to the next slide, is the healthcare proxy is a document that's valid, even if it's faxed, emailed, scanned, doesn't have to be original. I tell my clients, scan it into your email so you have it wherever you are. When you go to your doctor's office for a regular visit, I know I go to Northwell and they already have my healthcare proxy in their system. They ask me for it. Do you have a healthcare proxy? They scan it in. So anywhere, within the Northwell system, any doctor would have it. If you have a specific doctor you go to every time, or a specific hospital or treatment center, or whatever you have, give them your healthcare proxy. It's not a private document. It's meant to facilitate your wishes. Okay. Do you have a cemetery plot prepaid? Or where do you want to be buried? Or do you want to be cremated? And what about pre-need funeral planning? By the way, I don't sell any of this. I'm just telling you about it because I am a big believer. So here's another personal story. As an estate planning attorney, I was able to do the pre-planning for everything for my mother. When my mother passed about 5 years ago, everything was organized, including her burial. It was already planned. We had already made the arrangements, paid, etc. All I had to do was call the funeral home and they took care of everything. I have to tell you, that was a great relief for me. Again, I don't sell this, but it was a great relief. I was able to deal with my feelings and with mourning for my mother. I didn't have to worry about, oh my gosh, the money and which casket do I buy and where do I go and how. That's really not a great time to be thinking about money. Funerals on Long Island often cost $12,000, $15,000. And I think one of the reasons why they're so expensive is that oftentimes people are making decisions when they're not always clear-headed. So think about that. Does it help you to make your plans in advance? Is that easier for your spouse, easier for your children? They know it's all taken care of. And do you have any specific instructions to provide to your agents? I see all kinds of things. I won't share them with you, but very family-centric, specific instructions. You know, if there are things you want, maybe you want to be buried next to a different family member. Maybe you want a certain type of service. Anything you want, this is a great place to put it. Okay, now we're going to move on to the durable power of attorney. It's called durable because if at any point after signing, which we call executing, after signing the document, if at any point you no longer have the capacity, again, we always talk about the mental capacity, the ability to understand and to communicate and to know what it is you're doing. So if at some later point you don't have that capacity anymore, it's still valid, which is great. Again, the power of attorney, like the healthcare proxy, is only good while you're alive. And unlike the healthcare proxy, which I said to you is only effective, it's valid, but only effective if you cannot communicate, the power of attorney is available immediately. So today, Zahava Schechter as well, I have a power of attorney. I can go to the bank, I can deal with IRS, I can deal with Social Security, Medicare, I could sell my house, I could do all of those things, but so can my agent. My agent can do it. It's a very powerful, dangerous document. Powerful, wonderful, because if I am not able to do so and no one can access my money or access my property or do what's necessary for me, then people will have to go for a guardianship action, which often costs $15,000 or more. Power of attorney prevents that from happening. It's an excellent program, an excellent document. However, you have to pick your agent wisely, somebody you trust, somebody who's good with money, somebody who can keep accurate records, someone whom you think is not going to empty your bank account and leave you with nothing. So your choice of agent, just like for the healthcare proxy, your choice of agent was important. Your choice of agent here is crucial. Pick your agent wisely. Very important document. It applies to everything but healthcare. As I said, it's valid if you later become incapacitated. Once again, you want one agent at a time, and you have successor agents. Interestingly, in New York State, the agent must sign the document that the agent agrees. And that's because prior to 2010, that was a change in the law in 2010. Prior to 2010, you could name any agent, and the agent didn't have to sign. And what would happen sometimes is when the need arose and the principal is the person who signs the power, right? When the principal needed the agent to act, the agent said, wait a minute, Zahava never spoke with me. I never agreed to any of this. And the whole thing was a waste. So now the agent, since 2010, the agent must sign. Every agent, and successor agent too, must sign and say, yes, I'm willing to step up to the plate. Frankly, it's a thankless job. It's a lot of work, but I'm doing it for Zahava, who is the principal, and therefore I'm willing to do it. Interestingly, I don't know if you heard in the news, Governor Cuomo signed a new power of attorney law, which is in December, which is due to take effect in June. One of the things that the governor was concerned about, and in fact, the Trust and Estates Bar here in New York State was concerned about, was elder abuse and the fact that fiduciaries, agents who were not well known to the principal, to the person making the power, were actually stealing money. There was a question of that. So there are a lot stronger guidelines now for the powers. I would just say to you, whom you choose is really important. If you trust that agent, just know that agent has a great deal of power. Okay, and finally we get to, for the foundation, remember we talked about the foundation of the house? Finally, we get to the last will and testament. So why do we call it that? And again, it's valid, but it's not effective until you die. So why do we call it a last will and testament? Because you can make a will today, tomorrow, the next day. They're all valid. But the one that's effective, the one that the court is going to enforce, is the last one. Here, we don't call the person who marshals all the assets and then distributes an agent. We call that person an executor. In Florida, they call that person a personal representative. They're different names. It's all the same thing. It's a fiduciary, someone who acts on behalf of other people. Here we have an executor, a successor executor. What are some things that go into a will? A bequest. A bequest is, I leave the Bayville Free Library $5,000. That is a general bequest. $5,000 is going to go to the library upon my passing. There are also many kinds of bequests, including charitable bequests. And then you have, of course, residuary, everything else. Oftentimes when there are spouses, it's, I'm leaving my spouse money. And if my spouse predeceases, then to my children or to other people, but it's not always that way. And there's one other thing I want to say right here before we go on in the will. Between legally married spouses, what does that mean? That's not common law. That means you actually are married by the state. Legally married spouses, you could transfer to each other during your lifetime or after your death any amount of money you want, trillions of dollars. And there is no tax, none, no gift tax, no inheritance tax. There's no tax, none whatsoever. It's a great thing. Actually, I credit myself with at least 2 marriages in the last year. People were living together and I told them this and said, not only can you save money in different ways, but when you die, you can inherit from each other with no tax, and they got married. But anyway, neither here nor there. My point is, you say to yourself, well, what about my children? I want my children to get the money. Anyone other than a legally married spouse who receives money by inheritance, other than life insurance, we'll get to that, has to pay tax on the first dollar. I'm going to say that again. Anyone other than a legally married spouse who receives an inheritance not life insurance, pays tax on the first dollar. So if you're, a man and woman, or in New York, we recognize same-sex marriage. If you're not legally married, even if you're together 50 years, and if you inherit from your significant other, you're going to be paying tax on every dollar that you receive. It's a big issue. And I'll just say here, I'm sorry, I'm digressing a bit. Life insurance. I was talking with someone about that today. Life insurance is an excellent form of estate planning. I believe in term life insurance if you have a reason for it. Someone's dependent upon you, whether it's a spouse, a child, a parent, dependent on you. If something happened to you, how would that person survive? How would that person have enough money to live on? What's beautiful about New York is that proceeds from life insurance are not taxable. So if I have a term life insurance policy, which is fairly inexpensive, a term life insurance policy, and my daughter is the beneficiary, she is not going to pay tax on the life insurance proceeds. Although if I left her money in my will, she is going to pay an inheritance tax on that. So it's something to think about. Also, not every state is like that. New Jersey, for example, does tax life insurance proceeds, but New York doesn't. So that's good. We'll take it. Let's go back to the will. Sorry, I digressed. The will can only be properly executed. Remember, I said that means sign if you're over the age of 18. If you're under 18, that means you're a minor. You are not legally competent to make legal documents, to make decisions. Even if you think you can, legally, it is not enforceable. 2 disinterested witnesses need to sign. That means not somebody who is related to you blood-wise, not someone who has an interest financially in anything going on. I usually use neighbors if I'm at a client's home, or just people who have nothing to do, maybe they're friends, but they have no either pecuniary, financial, or blood relationship to the testator. That's the name of the person who signs the will. Oftentimes when I deal with clients who have minor children, they're very worried. What happens if they both die? Who's going to take care of the children? This is very interesting. In New York State, you may say in your will, I want my sister, brother, parents, whomever, to be the guardians for my children. But it's the court that makes the final decision. The court that has sole jurisdiction or sole ability to hear these kinds of cases involving deceased persons is called the Surrogate's Court, Surrogate ''S. Whether you're in Suffolk County, Nassau County, it's wherever you reside, that court will hear this case, and that court will determine who the guardians are. And in my wills, when I deal with testators with minor children, we are very specific as to why we're choosing certain people and not others. What are the reasons? Maybe they have the same religious values or the same family values, or you're close and you know each other well. Many reasons go into that decision. Finally, we're going to talk a little bit about a trust. People often say to me, oh, I need a trust. Oh, because my neighbor got the trust. Well, just because your neighbor has a trust doesn't mean you need it. So what is a trust? So let's talk about that very briefly. In the will itself, you can leave a trust, but I want to just do a general explanation. A trust is an entity. Think of like a circle. It's an entity. It doesn't have anything in it unless you fund it, unless you put money into it, or property, or some other item of value. And then the trust is governed by a document which has all kinds of rules. And we're going to get into why you would make a trust. And the important person who controls the trust is called the trustee. So this may sound a little complicated, but the bottom line is there are all kinds of reasons to put trusts into wills. One reason is, let's say you have a child or other family member with special needs. This often happens. The person is receiving governmental assistance. And if that person, that beneficiary, would receive the money outright, meaning the money is given to that person, they're knocked off of Medicaid, they're knocked off of SSI, or all other kinds of programming. As a result, it's really important to set up for that person a special needs trust. There are other trusts. I'm not going to go into all of them. We'll talk about them in a minute, but just keep in mind that the will is one place where you can put your wishes in for someone who especially needs a little more assistance and preservation. Some miscellaneous matters. Oh, I see we're half an hour in. I really want to talk about this. Bank safe deposit box. Please don't have the bank safe deposit box. If you have it, if you can, please remove your items from there and choose a fire safe box in your home. And people say, oh no, why? Why would I do that? And the reason is because even if you have two people on the safe deposit box and one dies, the bank will close the box and the survivor will not be able to access the box. That's how it goes. And then the lawyer takes more money because I have to file a safe deposit box opening petition to get in there to see what's in the box. And we have to do an inventory and it's a lot of money. By the way, when you plan, the best part is more of your money goes to your beneficiaries and less to the lawyer. I say that as a lawyer. The better planners who take the time and spend a little bit of money on the, on the front side, save a lot of money and a lot of heartache in the back side. So bank safe deposit boxes are not a good idea. I actually send to clients links. If you want to email me, I'll send you a link, whether from Walmart or Amazon, or et cetera. There's a great safe deposit box, not safe deposit, I'm sorry, fire safe box that is sold online. It's even shipped to you. Shipping is included, and you can put your documents in there and keep it in your bedroom or wherever you want. And it's very affordable. Long-term care insurance, something I've had for more than 20 years. A lot of people think, oh, Medicare will take care of me if I cannot take care of myself. Well, not exactly. So let's talk about Medicare, Medicaid. Medicare is age-based. You could be a multimillionaire and be 65 and you still qualify for Medicare, right? It's age-based. Medicaid, AID, on the other hand, is dollar-based. You have to be poor to qualify for Medicaid. So you could be 1 day old or any age. The issue is how much money you have. If you get to the point, whether you're 65 or not, and you cannot handle certain daily living activities, toileting, bathing, feeding yourself, dressing yourself, all of those activities, if you do not qualify for Medicaid, which most of us don't, most of us have a home or we have some money. If you don't qualify, and if you don't have long-term care insurance, you're going to be spending down all your money. You're going to be selling things or depleting your resources, which affects your spouse, which affects your other family members. If you're poor, truly poor, then Medicaid does take over. I can't say that Medicaid nursing home care is bad. I can't say that. And for people who have no safety net, it's a wonderful thing. But if you can afford to pay for long-term care insurance, then you get much better care for nursing home or assisted living in your home, or even an assisted living facility, not a nursing home facility. And you don't have to deplete your resources. And it's just a great thing to do. The kicker is you can only qualify for long-term care insurance when you're well, when you don't need it. By the time you need it, it's either too expensive or it's too late. So I've had clients in their 40s and 50s who have diabetes, who have heart conditions, who have Parkinson's. They don't qualify anymore. They don't qualify for long-term care insurance. So they have to make other plans. Obviously, this is a longer discussion, but I want you to think about long-term care insurance. If you're relatively young and you're in great health, or at least good health, I recommend you look into it. Life insurance, we've already talked about term life. I'm a big believer in term life if you have people dependent upon yourself. And disability. What happens if you work in a certain profession and you become incapacitated? Your salary won't be there anymore. How are you going to survive? So these are issues to talk with an insurance agent about. Medicaid planning. I just want to say we've kind of touched on Medicaid. Gosh, I could talk for hours on this, but I'm not going to. The important thing to know about Medicaid planning, people come to me, oh, I want to plan for Medicaid. Okay, you're going to lose all of your assets. Your house will no longer be in your name. The bank accounts will no longer be in your name. You lose control. And they say, oh, but wait, I want to keep all of that. So my question to my clients, and I would ask you to think about this is, if you have money, whether from a house or from a bank account, why would society, New York State, pay for your care and allow you to keep all of that money? Truly, Medicaid is for the poor. This is a longer discussion, but there we go. Gifting. Do you know that you can give anyone in the world, actually, but certainly in the United States, it doesn't even matter their age, $15,000 or any portion thereof without any gift tax consequence, without filing a gift tax return? $15,000, up to 15. If you're married, it's 30,000. If you have a child with a spouse, that's 30,000 to your daughter or son and your in-law too. It's a great way to see your family enjoy and use the money during your lifetime. Just a thought. Check beneficiary designations. One of the things I tell clients in my first meeting with them, my introductory meeting, as we go through bank accounts, brokerage accounts, life insurance, everything, 401k, IRA, everything you have, checking accounts. Who are your beneficiaries? People ask me, what do you mean? Well, do you know that for every account you have, any account, any policy, there is an ability for you to name a beneficiary. It's either POD, payable on death, or TOD, transfer on death. And what happens? You don't have to go to court. The person, the beneficiary, doesn't have to go to court. Zahava Schechter dies, and my beneficiary comes to the financial institution, whatever it is, with my death certificate and that person, the beneficiary's ID, and gets a check on the spot. It's pretty good, right? It only happens if you have done your beneficiary designations. If not, no one's going to access it unless there's probate and there are all kinds of issues with the estate. Also, be careful when you name a beneficiary and that person either dies or is on Medicaid or some other government assistance, or maybe you've just fallen out and you don't get along with them anymore. Or maybe you were married to them and now you're divorced and you never changed the name and you've remarried and then you die and your first spouse is going to get it. I mean, if whatever you put on that beneficiary designation goes. So revisit those documents, revisit the bank. And if you don't know what I'm referring to or you haven't done it, please do yourself a favor. You're the only one who could do it. Go to every institution or contact them online now during COVID. Call them. Say, I need to make beneficiary designations, or I want to check and see, did I ever do it? It's the best thing you could do. Pre or post nuptial agreements for second marriages and beyond. So many of us marry for once and that's it, but many of us also marry more than once. And oftentimes when you marry a second time and you have children from the first marriage, you often, not always, but often want the children from the first marriage to get money. Well, there's only one person you cannot disinherit in New York State. Only one person. And that's a legally married spouse. Cannot disinherit unless you have a pre or post nuptial agreement. So that's a consideration if you're looking to get married again. Deed transfers. You own property and you want to put it in your children's name. There are all kinds of tax consequences as to basis and step up in basis. It's a little beyond this conversation. Sometimes there are reasons to do it, to make the deed transfer, to add your children to your deed, or transfer the property entirely. But a lot of times there are not. I'm moving on. To trust or not to trust, that's the question. So we've started talking about a trust as an entity. You must fund it. You must put something in. What is it not? It is not the answer to every problem. It isn't. Today, I spoke with a client of mine who was thinking of creating a trust. And he didn't want his daughter to be able to access money until she was 30 years old. Okay, so that's an issue of control. How, when, how much, who gets, who doesn't get. Those are issues involved. Inter vivos means during your lifetime, or testamentary. We already talked sort of about testamentary during the will. And revocable or irrevocable. Revocable means you can change it at any time. You can't do Medicaid planning with a revocable trust, but you do hold on and control your assets. So, you know, there is no one answer to every problem. The best that can be done is to talk with your lawyer, your accountant, your other family members, and figure out what's best for you. Okay, so why create a trust? It's all about the control. As I said, who, what, when, how, where. We talked about government assistance. We talked about Medicaid planning, spendthrift. Do you have a family member who spends everything in his or her pocket? They get $1 and it's gone. That's a person you want to watch out for. You may want to control the money with a trustee so that that person doesn't spend his inheritance, whether in Las Vegas or addiction, drug addicts. Unfortunately, we see that in our society. Sometimes there are reasons to control how people get the money. Ease of administration. Any trust does not go through probate, does not go through the courts. And so you don't have that court proceeding. Again, just like the agent we talked about for the healthcare proxy and power of attorney, as well as for the will, choose your trustee. That's the person who administers the trust, and a successor wisely. That person, the trustee, acts in the best interest of the beneficiary. May you be the grantor, the person who starts, who creates the trust, the trustee, the person who handles the trust, and the beneficiary, the person who receives the money from the trust. Yes, only if it is a revocable trust for your benefit. Otherwise, no. We're almost done. 2 quotations by Benjamin Franklin. In this world, nothing can be said to be certain except death and taxes. You know, only 40%, only 40% studies show of American adults have done any form of estate planning. The other 60% say, oh, it's not going to happen to me, or I'm too young, or I have plenty of years. And then things happen. The courts are flooded with cases and scenarios where people don't plan. By failing to prepare, you are preparing to fail. Benjamin Franklin. So if I see that there's some questions, I'm going to go through it. Feel free also to contact me afterwards. And I hope everyone is well. And my office is in Westbury, but we can do things virtually. And I'm going to get off the share. Hold on a minute. And here we are. Okay. We're going to do a gallery view. Excuse me. So Christy, do you want me to go through this, or do you want to read them out?
Sure, I can read them out for you.
Okay.
All right. So let me just get to the top of the chat. Bear with me one second.
Actually, I see. So I'm able to get in.
You got it?
My daughter is an attorney in Georgia. Great. Can she draw up a will and other basic estate planning documents? You cannot offer legal advice, you say. Okay. So who asked that? That's Arlene. Who is Arlene? Can I see you or no? No, the trustee does get free. We'll get to that. Okay.
I'm here.
Hi, Arlene. Okay, so for whom is your daughter preparing the estate planning documents? For you, a New York State resident, or for somebody in Georgia?
No, I was thinking can she perhaps do this for me? I live in New York.
Okay, so I will tell you that every state has its own laws. As a result, I'm a New York attorney for over 30 years. I have no idea what Georgia laws are. I know how to prepare all these estate documents for New York. But what happens is a Georgia attorney, having nothing to do with your daughter, I'm sure she's an excellent attorney. A Georgia attorney is familiar with the laws, the requirements, the rules in Georgia. Now, if you told me she was also admitted in New York, then she could prepare the documents as long as they comport to New York. We have family members in Florida, and they needed wills and healthcare proxies and powers of attorney. And I found an excellent attorney in Tampa, near where they live, who prepared all the documents. Not because I don't know what I'm doing. I do this many years, but because Florida laws are different. Every state has different laws. So my answer to you, Arlene, is while your daughter, I'm sure, is familiar with Georgia law, if she is not familiar with New York law, she may make a major mistake.
Yes.
I'll ask you this. When you go to and I don't mean to pick on you, Arlene, anybody, when you have an eye problem, right? Do you go to an ophthalmologist or do you go to a cardiologist? So when you have, right, you go to the ophthalmologist. If I had a slip and fall, God forbid, right? It's going to snow Thursday. I'm outside and I fall.
Mhm.
I don't come to me. I'm not a personal injury attorney. I'm telling you the truth. I know nothing about personal injury other than what I learned in law school. I'd go to a personal injury lawyer. If you need estate planning, you should go to a specialist in estate planning.
Makes
That's my
sense.
advice to you. You could talk
Makes
to your daughter. When I said I prepared my mother's documents, my mother lived in New York. And so I was able to help her. Had my mother, I'm being honest with you, had my mother lived in another state, I would not have done it.
I see. Thank you.
Thank you. Okay. I hope that answered that. Let's see what else is in the chat. Can you give an example of something in between? That's C. Venice. Okay. Hi.
Hi, yes, it's me. So in particular, I was looking at end of life wishes.
Yeah.
Do not resuscitate or keep alive at all costs. So I was just looking for an example of something in between.
Okay, an example of that is I don't want artificial feeding, but I do want cardio resuscitation. I want I'm trying to think, I could pull up my healthcare proxy and all the different things that we could pick from.
But do you have to list them out? Because
Yeah.
I mean, I think earlier that you said that the doctors would, try to resuscitate you to the best of their ability. However, if you were like incapacitated or on life support, so that's what I would consider, whatever, end life. So I was just looking for something more specific.
You asked great questions and I want to respond. First of all, if you're incapacitated and you cannot communicate, and you don't have a healthcare proxy, the doctor is going to make the decision. And I can tell you, because I've spoken with lots of doctors, they will do whatever they have to try to keep you alive. And as you might surmise, the reason is they don't want to be sued for medical malpractice. I don't do personal injury work, so I can say this. I can say this honestly. A lot of the cases that are involved in medical malpractice are because the doctor didn't do enough, didn't do the right thing, didn't try hard enough, right? When you're doing everything as a doctor that you need to do and it doesn't work, no one's going to fault you and say you didn't try hard enough. So that's why, if that's what you're looking for, intervention work, that's what the doctor is going to do. Having said that, I want to say one other thing. I do put in my healthcare proxy, no this, yes this, whatever it is. However, if you name me your agent, and Zahava's the agent, and Zahava says, okay, what's your first name, if I may ask?
Cindy.
Cindy, hi Cindy. Okay, Cindy writes in her healthcare proxy, I don't want forced feeding. But Zahava's the agent. Zahava can decide we're going to do forced feeding. Now you may say, wait a minute, what just happened here? I have a healthcare proxy that says no forced feeding, but the agent is the one who makes the final decision. The instructions are guidance. They are not supreme. It's the agent who makes the decision. That is why the choice of agent, Cindy, is so important. Someone who will, number one, respect your decision, and number two, hopefully would do what you would do if you could. So like a lot of us say, oh, I would never do this, or I would always want this, but we can't plan every scenario. You have to trust that your agent will talk with the doctors and understand. A lot of times people will pick a nurse, especially if it's in the family, a nurse or a healthcare professional, because that person understands. I have no idea. If I were reading a medical record, me personally, I have no idea what it means. So oftentimes you want to pick, if you can, if you have someone like that in your family, a healthcare professional who will understand what is going on. But you have to rely on that agent to make the best decision he or she can at that moment with the information available. I hope that was helpful.
No, it's very helpful. Yeah. I mean, I just like, there's a line always that's always gray between do not resuscitate and keep alive at no cost. So I was just curious, like an example.
And I see here you wrote, for clarification, you can assign an agent. They don't have control until the principal becomes incapacitated.
Okay.
It's not incapacitated. It's lack of mental, it's not a physical issue at all. It's a mental inability to understand and to communicate. I've had clients, believe it or not, who blink, right? 1 for yes, 2 for no. They can blink. That is communication. Maybe not as great as we would want, but that's there. Now, I think you also wrote there has to be a tax loop.
Sorry.
I don't know what that means.
All right.
Oh, that was for if you, oh my gosh, I forgot now because that was like.
All right. I have, I'm sort of going down the list. So the next question was from Thomas.
Okay.
He asked, when you say pay taxes, which is pay taxes on inheritance, are you speaking state, federal, or both?
Hi, Thomas. Are you talking about the life insurance proceeds or are you talking about the other inheritance?
I believe he was talking about the inheritance tax.
The other inheritance, yeah. The life insurance, you said there was no taxes on. I think I'm clear on.
In New York State.
Okay.
If you're a New Jersey resident, let's say the testator, the person who or the insured, the person who made the policy is a New York resident. But you are, Thomas, let's say you live in New Jersey. I say New Jersey because I'm very familiar with that. And you live in New Jersey and you receive the inheritance, it is taxable to you. It's wherever the beneficiary lives. So I'm talking about people who live in New York State.
Okay, so that's for insurance.
Right, okay.
Now,
let's say I leave a will, Thomas, I leave a will and you inherit from me. You are taxed on the first dollar. How? It's not an estate tax because it's my estate, not yours. It is income to you, income. As a result, all income is declared on your 1040. I don't know your tax bracket. That's how it's going to affect you. So it could affect you statewide. It could affect you for federally as well. It's income.
Okay, so any income as a New York State, any inheritance dollar in US dollars, right? As a New York State resident, you pay state and federal income tax on.
Maybe not. I don't know your tax bracket.
No, but it gets declared as income.
It is declared, but again, if you're inheriting from your spouse, legally married spouse, $0, there is no inheritance tax from your spouse, none, zero.
So if you get it from your father, your uncle.
Yep.
Okay. So it's not considered a gift.
Well, let's talk about it. Remember we said gifting up to $15,000 a year? Gifting is while you're alive. You can't make a gift if you're not alive. So let's say your father gifted you on February 16th. Your father gifted you $15,000 or any sum up there. And God forbid your father died the next day, February 17th. The gift is completed.
Got it.
It's while he's alive.
I
So
see.
be careful with the inheritance. That's why life insurance proceeds, especially for New York residents, are great. It's not considered income.
Yeah,
Okay,
but when you're saying life insurance, you're saying divert their assets into a life insurance. Is that what
I'm saying I have a policy. I'm the insured. It's on my life, Thomas. You are my beneficiary. You live in New York State. You're not my spouse. You live in New York State. You inherit money through my life insurance policy. That is not taxable.
Now, is that true for federal too?
Not taxable. It is, yes, not taxable.
Got it. Thank you.
Sure.
Thank you.
Okay. Very good.
Okay. And then Thomas had also asked about when you select two witnesses, that they, does that mean that they shouldn't be beneficiaries?
Definitely. Oh, those are interested people. Think about this. I make a will and I name Thomas as my beneficiary. He's going to inherit and he's going to be the witness too. No, that would be struck out right away. So no one who has a pecuniary, whether financial interest of any sort, whether that person is in business with me or is likely to inherit. There's actually a question as to whether the executor, the named executor, can be a witness, but I don't do that because I don't want any question. I don't want my wills to be, and they've never been, I don't want my wills to be knocked out for any reason.
Thank you.
Thank you.
Okay, and then we had another question from Cindy, or a comment that's saying another reason to have a trust is that if you pass away and everything goes to your current spouse, then the current spouse remarries and passes away. All of it goes to the new spouse and your children are not protected.
Well, yes and no. So there's a lot there to unpack. I would suggest if you have a new spouse that you have a prenuptial agreement. That is the best way to ensure that your children will inherit and not your new spouse. Because I told you that you cannot disinherit a spouse. That's the only person you cannot disinherit. In fact, today I met with a client who has 3 children and he's disinheriting 2 of his 3 children, which for his own reasons, you can do that. You just cannot disinherit a spouse. And I'll just tell you a little bit of the history. What had happened was, and I love men, I really do, but a lot of men were ending their first marriage and marrying much younger women. And then this is just fact. This is how this came up, that meant that no spouse can disinherit another spouse. And then there was nothing being left by will for the original spouse, and the second younger spouse was getting all the money. So New York State Assembly said, no, this cannot work. So the surviving spouse, if you're legally married, surviving spouse gets not less than 1/3 of the decedent's money. But neither here nor there. I'm just sharing with you a little bit of history. The other thing is, if you do name a current spouse as a beneficiary for whatever reason, and then you're divorced, go back and change that beneficiary designation, because it will not happen automatically just because you've divorced. You have to affirmatively name someone else.
Okay, there was a little bit of a discussion about the safety deposit box versus the fireproof box. If you put valuables in a fireproof box, it can easily be stolen from your home. Right?
Yeah, you know, people do say that to me, and I guess if you don't mind that the lawyers are going to make some more money and have to get another proceeding to open up the safe deposit box, that's fine. I understand if you have those kinds of valuables. In general, and I got 2 fire safes in my office because I prefer clients take their documents, but oftentimes they don't want them. They want me to hold them. They think I'm more responsible, whatever. Anyway, so I have a lot of wills and other documents. And the idea is not against theft. The idea is, if something happens to you, your family can access the documents. Again, if you have a safe deposit box and you die, even if there's somebody else on it, the bank will not let the other person in. You're right about jewels and theft. It's not a theft issue. It's an access issue.
Okay, so if you and your spouse both have access and you're alive and you both have access to the safe deposit box, if one spouse passes away and the other spouse goes to the bank and empties the safe deposit box before the bank is notified that the person died, right?
Okay, so that's illegal.
Okay.
And I don't want to
mind.
know. I don't want to know, so don't tell me.
Okay, enough on the safe deposit.
And I didn't say that that's a good idea. I deny it.
Okay. There is
go ahead.
some questions about whether a trustee gets a fee.
Okay, before that, I see a few other things before that.
Did I miss something?
Does the beneficiary have to be over 18? Cindy asked.
Me.
Yes and no. A beneficiary who is not at least 18 years old cannot receive an inheritance.
So that's, you would have to set up a trust for that, correct?
It would be set up, yes. It would
until he's 18. Okay, that's my question.
And Medicaid planning, Arlene writes about a 5-year look back. Yes, you're right, Arlene. Not only that's for nursing home care. So for example, if today I divest myself of my house and my bank accounts, and I give everything to Thomas today. And 5 years go by, 5 full calendar years go by, and February 16th of 2026, I need nursing home care. Medicaid then can't say, oh, well, 5 years ago, you transferred everything for no money. You just gave it to Thomas. Therefore, we're going to go back and take your house, etc. 5 years go by and those assets are protected. There is an issue with basis and capital gains, but I'm not going to get into them here. I just want to say that as of October 2020, New York State applied a 30-month, that's 2.5 year, 30-month look back period to assisted living situations. So Medicaid nursing home does have a 5-year look back period. Medicaid assisted living, which is called community-based, has a 30-month period. Okay. And the safes, I said you can look on Walmart or whatever.
Does a trustee get a fee?
Yes, a trustee gets a fee, an executor gets a fee. Yes, it is statutory. New York State sets the amount. Yes.
Can someone transfer their house to their daughter and still retain ownership?
That's a really good question that comes into the deed transfer issue. So the first thing you should know, who asked that? KOD, who is that? I don't know if you want to speak up. Okay, if you don't want to speak up, it's all right. The first question I'm going to ask you is, and you can ask yourself, how much did you pay for the house? So a lot of times people paid $30,000, $40,000, $50,000 for a house that's now worth $500,000, $600,000, $700,000, right? Okay. Every person during their lifetime has a $250,000 exemption from capital gains tax when they sell their primary residence. I'm sorry, I don't want to get too much in the weeds here, but that means if I purchased my house for $50,000, and when I go to sell my house, and we're not talking about improvements or whatever, when I go to sell my house, I sell my house for $300,000. What is my improvement? What is my gain? How much more money is my house worth today when I sold it from when I purchased it? $250,000. The IRS says, okay, you have a $250,000 exemption, Zahavi. You don't have to pay any capital gain tax. That's a great situation. But what happens when you transfer during your lifetime for no money, that's called no consideration, for no money, you're going to transfer the house, at least part of the house, to your daughter. Your daughter is going to get part of that $50,000 or whatever the cost basis is. Again, I'm trying not to be too confusing here. And as a result, when your daughter goes to sell, or whoever goes to sell, there's probably going to be a capital gains tax. I would suggest to you that you speak with an accountant and an attorney before you do that. And I'll share with you an example. I had a client, they have a lot of husband and wife, they have a lot of properties. Most of them are in both of their names, which is good for many reasons. But one property is in the wife's name from before the marriage. They've been married over 40 years. It's upstate in the Catskills. And she purchased the house for, I don't know, $30,000, $40,000, et cetera. It's now worth $500,000. And they said to me, they asked me, should we transfer it to our names? Because almost everything else is on both names. And I said, no. And the reason is, if they transfer it now, she's not going to be able to preserve her ability to get a step up in basis to prevent capital gains tax. It's a little complex, but there are sometimes reasons yes, and sometimes reason no. So KOD, I don't know if that answered your question, but I wouldn't rush to do it. I would definitely talk to an accountant and a lawyer to see, is it a good idea tax-wise for your particular situation? In my client's situation, it would have meant a $60,000 tax hit. So we said no. She's going to wait
Okay.
until she passes.
We
Okay.
have a question from Mike, who's going to be moving out of state in 3 years. Should he wait to plan? The kids will be staying in New York.
Okay. Has nothing to do with your kids. So you're basically asking me, Mike, what tomorrow is going to bring. I don't even know what this evening is going to bring. Are we going to stay alive, tomorrow, the next day, 3 years? I don't know. If you said to me you were leaving next month, I would say to you, wait. 3 years, I personally wouldn't wait. I would make the plans because we don't know what tomorrow brings. And if anything happens between now and 3 years, even if you're alive, but you're incapacitated, there's no way you'll be able to make the documents if you leave. So 3 years is kind of a long time. I would say don't wait, but that's my personal opinion.
Okay, and then this is KOD again. The tax issue, her daughters are beneficiary and she has to pay taxes on what she gets.
All right, hold on a minute. Beneficiary and being on a deed are two different things. I don't know, KOD, if we're still on the deed issue.
No, I think we're on the issue of tax inheritance.
Okay, I just want to say, that's okay. I just want to say, clarify, on a deed, there is no beneficiary. You're either the owner of the property or you're not. You either have some kind of interest in the title, the ownership of the property, or you don't. There is no beneficiary situation. So under what circumstances would your daughter, as beneficiary under a bank account or a will or whatever, she's going to pay, except for life insurance, she's going to pay on the first dollar tax, and it's income. So it's going to be her tax consequence is going to be based on where she is now. How much money does she earn? Does she earn $5,000 a year? Does she earn $300,000 a year? I have no idea. It's every beneficiary has his or her own tax bracket, tax situation. It is considered income. It's passive income, but it's income nonetheless, and it must be reported. I hope
And
that's
if
a question.
if it's in a trust, is it taxable?
Okay, so that's a great question. Let's say Zahava Schechter has a trust. The trust is holding $5,000. Thomas is my beneficiary. If the trust makes no distribution, meaning Thomas doesn't get even $1 from the trust, there is no taxable event to Thomas because he didn't get the money. But if Thomas gets the money from the first dollar, whatever he gets, that is income. So if you have a trust and your beneficiary is getting money, then that beneficiary is liable to a tax consequence to the extent of the income received.
It's just on the income received, right? So if I put money, like I want to set up a trust for my life insurance, which is non-taxable to.
No. You don't. I don't understand why you would do that. Have a life insurance policy.
I have a life insurance policy, but I would want to transfer it to my son.
Okay.
Under 18.
Oh, under 18, he's not.
But then he doesn't have tax consequences because it's,
Yeah, but he's under 18. He can't inherit.
I have to put a trust in. But any money gained on that trust would be taxable to the trust. It's a trust.
So that's not a
But
good,
the
that's not a
initial.
good way to go.
Okay, so I'm going to talk to you then.
That's
I'll
not
talk
a
to you.
good way to go. And one other thing, let's say, remember I said Thomas is my beneficiary? I have $5,000 in the trust. Thomas only takes $500. So he's not going to be taxed, even though he could take the $5,000. This is how wealthy.
It's only taxed on distributions,
Exactly.
right?
This is how wealthy families get even wealthier. They don't take, everything stays in the family trust and grows and grows and grows.
All right. Okay, I'll talk to you later.
Okay, thanks. Anything else?
I'd like to thank you for all the money you're leaving me and all the assets. And this is being recorded, so thank you so much.
You're welcome. I hope.
May I ask you a question? I didn't put it in the chat.
Go ahead.
So my question relates to the $15,000 gift tax rule. I want to know if it comes into play with the following. If I have a joint account with my adult son and I transfer money from my account into that account, does the $15,000 rule come into play?
That's a really good question. And the IRS has made many rulings about these so-called convenience accounts. Meaning, if you're the only one depositing to the account, even though both of you are joint owners of the account, then that's considered a convenience account. That's not really a gift because you can always access that money, right? Just because you deposit doesn't mean that you've given up control. You could also withdraw that money. So
So
that's not a good gift.
okay, so in a sense, I can really give money without any tax consequence by this route.
Up to $15,000. You can give
No, I meant
Thomas-
beyond that. In other words, can
wait, wait. We got to talk about up to 15,000, and then we'll go beyond. You could give Thomas, you could give John, you could give Peter, you could give Chrissy, you could give everybody. You don't have to be related. Up to $15,000
Yes.
with nothing. Now, let's say you want to give $15,001. Now you have to file a gift tax return. It's a one-page deal. It's a one-page deal in that year. So for example, you would file, let's say you did it in 2020, you'd have to file it by April 15th, 2021. There's no tax assessed to you because you have a lifetime exclusion rate, which trust and estate attorneys think will go down. We have a change of administration. We have a major deficit. The estate tax is really high. In New York State, the threshold, I'm getting to your point, Jean, the threshold is about $6 million. If you die with less than $6 million in New York State right now, you don't really, around that, you don't pay estate tax, and the federal amount is about 12 million. That's very high. And that's why, you know, with all of the, I don't want to get into politics, but with all of the financial difficulties our government is having, most trust and estates attorneys think that those numbers will come down. So Jean, if you give over $15,000, you must file a one-page gift tax return. But I'm going to give you another idea, which is you can give $15,000 within a calendar year. That is, remember we talked about Medicaid at 5 years down the road, that would be February 16th, 2026. It doesn't work that way with gift. Gifting is January 1st through December 31st. So you could give by December 31st, 2021, up to 15,000, and you could give January 1st, 2022, another 15,000 to each person.
My main question was putting money from into that joint account with my adult.
Yeah, but that's
son.
not a gift. You still have control over it. You could.
Okay,
still
so there's no, so I meant to say that's a way of avoiding the gift tax in a sense.
Okay, so what you're doing is you're transferring to yourself, basically, any amount of money, which you certainly could do. It just so happens in that account, your son also has access.
Okay,
Is that what you're telling me?
yes.
Just be careful, because if the IRS would ever question that, you know, you should always keep your records at least 7 years. If the IRS would ever question that, you would have no defense, basically, because you can't show that anyone other than yourself, you're the only one transferring, and yet he's the only one withdrawing. Just be careful. I have another idea for you, but you can't tell anyone I'm saying this, Jean, okay? Just between you and me. You can always withdraw some cash, and then what you do with your cash is your business. You know what I mean?
Redeposit it back into the account.
I don't know. You do what you want with it.
Thank you.
If you redepose it back into the account, it's still a dual controlled account. So
Right.
the
But-
point is that, you know, you have to, like a revocable or irrevocable trust, you have to not have any control over that, I think. So in order for it to be a gift, it has to be a gift, right?
Well, gift means you lose control. So revocable would not apply.
Convenient.
But I want to say one other thing for anyone looking to withdraw more than $5,000, 5,000, actually, I should say 5,000 or above, that is reported to not Homeland Security, but I think it's like the money laundering
Yes,
agency.
Absolutely.
So,
Yeah.
so if you're going to start taking out large sums of money relatively, you know, do it on the lower end. Don't go near 5,000. And that's all I'll say today, because I need to keep my license.
I want to thank you. Lovely presentation.
Thank you. I hope you learned.
And I
had a
thank
good
you
time.
very, very much for the depth answers in which you gave and their clarity.
Thank you.
Compliments to the chef.
Thank you. Have a good day and stay well. Anyone else have questions?
Can you make sure you put up your information again? It was up for a short period of time, or if
Yes,
the library.
I will share my screen now. Hold on a minute.
And one thing I'd like to add is, if I'm not mistaken, everybody that goes to the Bayville Free Library has a net worth of above $12 million. So we're all.
Sure. Well, you know what's interesting, Thomas? Even if you have a lower net worth, which I know cannot be possible, we do think that with the change of administration, there will be a reduction in the threshold, and that lots of other people are going to get caught in the estate tax burden. So
Thank you.
it always makes sense to plan. So hopefully you can see my information. And are there any other questions, Christy?
I don't believe so, but I'd like to thank everybody for coming. Please check our website. We have lots of great programs coming up on all kinds of different topics. And
Thank you.
all right, Zahava, thank you so much.
Thank you. Stay well.
Stay
Thank
well,
you.
everyone.
Thank you very much.
Thank you.
Stay safe
Bye-bye.
in the snow on Thursday. Take care.
Thank you.
Bye-bye.